Be ready. 5 seconds.
Honorable Chairperson, Sir, I consider it my privilege to be able to speak on the company's Amendment Bill 2020. I am immensely grateful to you for giving me this opportunity. At the outset, let me offer my compliments to the Honorable Prime Minister Shri Narendra Modi and the Finance Ministry for taking this bold and much needed step to amend the Companies Act 2013. With this amendment, the central government has proved that it is not only responsive to the changing requirements of the business community in the country, but also it is capable of taking timely and effective decision in this time of crisis. This amendment will promote and encourage ethical business practice in the country and reinforce the belief of common and economic value creation. Sir, this amendment will result in ease of doing honest business and ease of doing ethical business. The government sees that there are operational problems when a particular act is being implemented. We should remember that it is an act of 2013. There were operational issues, and that is why amendments had to be brought in, and that is why amendments are being brought in today when I am speaking to you. Now, sir, the question is what the key changes are that are being proposed in this particular bill and what would be the benefits that would be accruing if these amendments are actually implemented on the ground. I would be categorizing all the amendments that have been suggested, that have been proposed under 7 different heads. Please give me some time as I am the first speaker from my party. I would be just elaborating on some of the key changes and the benefits thereof. It is very important for this august house to appreciate and understand the kind of benefits that would be coming to us. First, it empowers the central government to exclude certain companies from the definition of listed companies. This is Section 2 of the bill amending Section 2 of the Act. Now, what is the present scenario? What would be the benefit if this would be amended? Sir, Section 2 of the previous Act defines the listed company as any company which has any of its securities listed on any recognized stock exchange. Section 42 of the present Act, read with Securities and Exchange Board of India's regulations, indicates that in addition to public companies, certain private companies too are permitted to list debt securities on a recognized stock exchange. Now, what is the proposal? This amendment bill chooses to exclude or delist certain class of companies from the status of listed companies and to delist it in consultation with SEBI. Hard work has been put in while drafting this proposal. By virtue of this amendment, the provisions of the Act applicable to other listed companies under the Act can be made inapplicable to such private listed companies. This is the first key change, and this is what we are going to do once this amendment is accepted by this august House. The second key change is this. It proposes enabling of listing in foreign jurisdiction. A tremendous benefit would accrue if this is done. Now, what is the present scenario? The Act of 2013 does not allow the domestic companies to list their securities in stock exchanges in foreign jurisdiction. Neither the companies in foreign jurisdiction can do the same in India. So, sir, what is the amendment proposed? The bill empowers the central government to allow certain classes of public companies to list permitted securities in stock exchanges and permissible foreign jurisdiction. Permitting the direct listing of debt securities in foreign jurisdiction will help the domestic public companies by offering them a chance to access a larger pool of capital. This is likely to help our startups tap overseas market to raise capital. Startups are often on the lookout, as we know, sir, to raise capital, and this would permit them to do so without migrating to a foreign jurisdiction. Now, the third and the most important proposal is the key change that we have been talking of and that I heard my dear friend talking about. That is decriminalization of offences. This amendment bill introduces reforms in decriminalizing offences based on their gravity. I will be listing out 4 changes that have been proposed for the knowledge of the House. Sir, the benefit thereof would be that this amendment bill proposes to allow the company to pay the penalty, rectify their faults, and become compliant with the law through IAM framework. This will promote ease of doing business. In fact, this is what the fear is all about. People will be going scot-free. Corporates will be going scot-free. That is what has been raised. I was just listening to my dear friend. This will promote ease of doing business. This will boost the confidence of investors. The fourth is the corporate social responsibility. The bill permits a company which spends in excess of the mandated 2% to carry forward the excess spending towards their obligation for the next year. We have already discussed this. This is beneficial in case of CSR initiatives which require higher amount of capital, as this allows the company to invest in CSR initiatives and have the excess being waived off from the CSR obligation arising in the subsequent year. Sir, with introduction of a new chapter on producer companies, it will benefit the independent directors, and this is in fact to encourage them. They will be given awards and they will be brought at par with the executive directors because they have contributed to the betterment of the company and they should be encouraged. Sir, in periods like this, when India is struggling to deal with a pandemic of such magnitude, boldness in policy making and debt financial management is the key to recovery. With all the conviction at my command and with all humility too, I can say that this amendment would encourage business, investment, and entrepreneurship in the country.